accords a kind of special status to a category of women, that is married women.
Yeah.
So if you read A says 18, then for married women they are deemed to be of age. So in other words, it gives them an advantage over other women that are under 18. So you ask yourself why?
Okay, women who are married but under 18.
Yes.
Or the unmarried ones under 18.
The unmarried one under 18. Yes. Because if you read, it says...
No, but if you're unmarried and you're under 18, this doesn't apply to you, does it? Because renunciation of citizenship. Because if a man gets married to someone, isn't that why...
No, it says that if you are married, then you are deemed to be of age.
Yeah.
That's what it says.
Yeah, but from the context of this section 29 as a whole.
No, but
not
if
from
you
the immediate setting.
No, but if you read that, I think that was basically why there was this clamor for deletion, because that section is not necessary. If you fix the age at 18, then there is no need to now say that people that are married are deemed to be of age. So if I'm to go by what Senator Abaribe was saying yesterday, that there is already the Child Rights Act and all that, you remember that the Constitution takes precedence over the Child Rights Act. So if the Child Rights Act conflicts with the Constitution, the Constitution takes precedence.
No, but since this is about renunciation of citizenship and not about the age of marriage,
yes.
Can you cite this when citing age of marriage?
No, but the point is that for renunciation of citizenship, it puts people that are under 18 at a disadvantage.
So that's the discrimination
That's the discrimination I'm talking about. I don't know if you get the point I'm trying to make.
Okay.
So, whereas those that are married, that are under 18, can renounce their citizenship. Those that are not married, that are under 18, cannot. That's what it means.
That's a controversial bit. Those that are married under 18, it means that, of course, some laws allow you to be married under 18, even though they say the Child Rights Act puts the age of marriage at 21.
But that's why I'm telling you that section deems a married woman, deems a woman that is married to be of age for the purposes of renunciation.
Because your argument here now is because this is the Constitution, so it takes precedence over the Child Rights Act.
Yes, if there is a conflict
between
the Child Rights Act
we should be looking at now.
Yes. If there is a conflict between the Child Rights Act and the Constitution takes precedence. If you read that section 1.3, that's what it says. That if any law comes in conflict with the Constitution takes precedence. So that's the part about discrimination.
But you know, when they say using the word deemed in law,
it's as if you are. That's what it means. So it's assumed. When you say deemed, it means it's assumed that you are of age. So you can't renounce your citizenship.
But is this in any way ambiguous?
Yes, and that is why they should have deleted it and not retained it.
Okay.
You
so
see
you
the point?
Subscribe to them deleting this?
Yes, I did. Yes,
because
they would have done us a lot of good by deleting it.
Because that controversy on the floor, they couldn't come to a conclusion.
Yes.
They couldn't get the required number of votes. So, but maybe they should move another motion or point of order for deletion of this section.
Because as things stand now, we've not made any progress. And that's the point I'm trying to make.
What about the section 40 you talk about? What's the link?
No, section 42 talks about discrimination.
Oh, okay.
You understand? So if I have somebody who is under, 18 that is not married and who wants to renounce can now go to court and say, no, I don't understand why I've been denied the opportunity of renouncing my citizenship when I know a friend of mine who is married and is under 18 can do same. So you see the problem with that section. And then the other part, which is section 10, is that if you also look...
Prohibition of state religion?
Yes, if you look very carefully at section 29, 4B, you realize that it looks as if there is an attempt to preserve the sentiments of people of a particular faith. You know, because, of course, if you followed what happened at the National Assembly or the Senate, you realize that it was the position taken by Senator Ahmed Yerima that led the Senate to do another voting on this provision of the Constitution. Owing
to perhaps the ambiguity of this section.
Yes. So you realize that, for me, that's my take. I don't know. I was listening to Senator Abaribe yesterday, and he was saying, no, it had to do with the exclusive legislative list, item 61 and that. But I think the reason why the Senate did not delete that section was basically because they felt there was the need to preserve the religious sentiments of, and it's not just people of the Muslim faith. We also have people who practice customary law who think this section would preserve certain.
And then they also have their own age of marriage.
Yes.
The customary law.
Yes. So there are people people who practice customary law may also see an advantage in the provisions of.
So
this
in
section.
other words, your argument here now is even though we don't have a state religion, somehow with all these existing sections in the Constitution, we are almost gliding into theocracy.
Yes, that's why I started by pointing out that the real problem is the nature of constitution or country we want. Do we want a secular country or do we want a theocratic one?
From the science, what do you have? What do we have?
I think we're trying to have it both ways. A little bit of this and a little bit of that.
Can we?
Which is why we're having all this controversy.
But as presently constituted, do you think we can have it both ways? Or what do we have to do?
Yes, we can have it both ways if all persons or all groups are taken into consideration. We can have it both ways. But as things stand now, certain people feel left out.
Who feels
the Christians, for example. That is why my senior counsel, Isabakaba, wrote to the National Assembly about the need for the establishment of ecclesiastical or Christian courts. Because if we have in the Constitution the Sharia Court of Appeal and the customary Court of Appeal, why shouldn't we have an ecclesiastical or Christian Court of Appeal as well? To at least identify with all the other groups. So if those people that are practicing Buddhism in Nigeria also want to have they should have their own courts provided for in the Constitution.
Wow.
So our point is very simple. Is either we have a non-faith or a non-faith-based constitution, or we have a faith-based constitution.
When he says he believes that Nigeria is a multi-religious country and faith is personal, he believes matters of faith should not be contained in the Constitution as provided by Section 10, which prohibits state religion. But if you go with all of these courts, wouldn't that be identifying that?
That's the point I was trying to make, that we're trying to have it both ways. We're trying to have a little bit of this and a little bit of that. So you can't have Section 10 and at the same time be making provisions for faith in the Constitution.
So then he goes to Section 42, which talks about discrimination.
Yes, because if I also feel discriminated, why shouldn't I have my own ecclesiastical or Christian court if there are customary and Islamic courts of appeal?
In other words, when the train went around concerning the review of the Constitution, there are a whole lot of issues that the people should have raised, but we seem to have been bothered about state creation and so many other issues, to the extent that now this one that we thought was just not too important is what is causing confusion as we speak. Yes,
and that's why I think the National Assembly should be a bit more focused in this constitutional amendment, because for me, I think they seem to be wasting so much time on the periphery.
But again, how does it work? Because if you look at it, this is a letter written by Senior Advocate of Nigeria, Olise Agbakuba, directly to the Senate President. An individual, as a citizen, can also write and draw attention to some sections,
yes,
isn't it?
Several. I know of several people that have done the same thing. I think Dr. Abayomi in Abuja did the same thing. He also raised certain issues about the Constitution as to whether the National Assembly even has the power. Because if you've been following the amendment process, you realize that there is a section that makes provision, that tries to empower the National Assembly to make a new constitution.
For the country.
For the country.
Yeah, they debated that.
Yeah, so, so you have a right to approach the National Assembly.
Mike Ahamba also wrote to the National Assembly.
Yeah, so we have a right to, not just the Senate President, but to our representatives to point out things that we feel very strongly about.
And he says, if after 7 days.
Yes.